Good afternoon. Welcome all to our table topic number 1 on the challenges and opportunities of marketing and advertisement in the era of artificial intelligence and new technologies. The advertising industry is in a constant state of evolution, or should we say revolution. Innovation and technology continues to rapidly change how consumers interact with brands, allowing for more personalized and effective marketing campaigns. Machine learning algorithms have unlocked new levels of consumer insight. They recognize patterns in consumer behavior and determine which messages resonates best with each individual, so ads and marketing campaigns can directly target interest and relevant audiences, increasing the return on investment. Generative artificial intelligence comes to shake the advertising industry once again, allowing for the reduction of costs related to the content creation, greater possibilities of higher personalized content and ad messages, as well as for scaling, just to name a few. The potential legal and ethical issues associated with the use of these technologies in advertising is subject of our table topic, and I have the great pleasure of introducing our speaker today, Thorne Maginnis, associate at ArentFox Schiff in Washington, D.C. Thorne has broad IP experience with a focus on trademark and copyright portfolio management and counseling. His IP practice extends to clearance, prosecution, enforcement, and dispute management, and he frequently counsels clients on IP matters pertaining to AI and other emerging technologies. His IP practice is complemented by expertise in the fields of advertising and e-commerce, where he advises clients on federal and state false advertising, unfair competition, consumer protection, and internet laws and regulations. Well, thank you, Thorne, for being here with us today. This is an interactive discussion, so I have asked Thorne to share his thoughts first, and then I'll open for questions from our audience, here both in the audience and online. And by the way, I would like to ask our online audience to submit your questions through the chat, and I will read here at the end. Thorne, the floor is yours. Thank you.
Thank you, Fernanda, for the kind introduction. It's a real pleasure to be here with you all today to discuss such an interesting and cutting-edge legal topic. The purpose of today's discussion is to explore how U.S. advertising law is adapting to emerging technologies, specifically the interrelated developments of the metaverse and artificial intelligence. We'll begin with a brief overview of U.S. advertising law and some recent trends before taking a deep dive into the metaverse and AI. In the U.S., laws regulating advertising and marketing activities can be split into two general groups: false advertising and unfair competition. At the federal level, the Lanham Act prohibits false and misleading advertising. It authorizes claims by any injured party based on a false or misleading representation of fact about their own or another's commercial activities. Most states have similar laws. While unfair competition laws can also be used to combat false advertising, their scope is generally broader, extending to a wide range of unfair or deceptive practices. At the federal level, the Federal Trade Commission has a broad directive to protect consumers against unfair or deceptive acts or practices in or affecting commerce. This authority has been used to target a wide range of activity pertaining to, for example, endorsements, consumer reviews, influencers, commercial email or spam, e-commerce shipping practices, online disclosure of terms and conditions, green advertising, health claims, and more. Many states have similar unfair competition laws. These laws, particularly California's, which is notoriously broad, are often utilized in consumer class actions targeting commercial conduct that does not technically involve a false or misleading statement, but which is nonetheless perceived as being unfair or deceptive or creating consumer harm in some manner. In 2022, the FTC released a report unveiling one of the buzziest terms in the consumer protection landscape, dark patterns. which the agency has described as any user interface design intended to trick or manipulate consumers into purchasing decisions that they wouldn't otherwise make. The scope of what might constitute a dark pattern is potentially very broad and not entirely clear at this point. But some examples include drip pricing, that is, advertising only part of a product's total price to lure in consumers and not mentioning additional mandatory fees until much later in the buying process. Creating a false sense of urgency, for example, using a fake countdown clock to make consumers think they have a short amount of time to complete a purchase or else they'll lose the product. Similarly, falsely stating that there is limited inventory is considered to be a dark pattern. Confirm shaming, that is, using language that makes a consumer doubt their choice to decline an offer. For example, making a consumer click, "No, I don't want to save money," in order to decline an offer. In the coming months, we will see how the FTC targets dark patterns and what practices are prioritized for enforcement activity. Next, influencers. Under the FTC's rules governing influencers, the core requirement is that the influencer must clearly disclose their connection to the brand that they're endorsing. The FTC's influencer rules provide specific disclosure requirements, and over the last year, the FTC has increased its enforcement activity related to non-compliant advertisers and influencers. The FTC recently finalized its updated influencer rules, which, as we will discuss later, have modernized the rules to address emerging technologies. And finally, consumer class actions, which have long been a fixture of the U.S. legal landscape, continue in significant numbers. They can cover a range of topics in the false advertising space, but lately, many consumer class actions have focused on product labeling and origin claims. For example, the popular pasta brand Barilla is defending a lawsuit alleging that its claim to be Italy's #1 pasta constitutes false advertising because the pasta is not actually made in Italy. The pasta is made in plants in the United States. However, the company does have origins in Italy, and the packaging discloses that the product is made in the United States, which Barilla says is enough to defend a false advertising claim. That case is still pending. Similarly, Texas Pete's hot sauce is defending a lawsuit based on the fact that its hot sauce is not made in the state of Texas, it's made in the state of North Carolina. So, as you can see, claims that are used to add value to a product by enhancing its perceived authenticity or legitimacy require careful analysis under U.S. false advertising laws. Now let's begin our look at the first of two emerging technologies we'll discuss today, the metaverse. What is the metaverse? Well, the answer to that question might seem obvious at this point, as the metaverse is no longer a brand new concept. But what I would like to emphasize is that the metaverse is a potentially broader and bolder idea than the current avatar-driven digital platforms that we're all aware of. Really, the metaverse can refer to any type of virtual immersive experience that occurs online. As virtual reality technology evolves and current metaverses increase their interoperability, the metaverse is likely to become increasingly integrated into our daily lives. In the coming years, we might wake up and put on VR glasses to review our emails and social media feeds, or to review the news in a visually immersive way. By doing so, we will be entering the metaverse. So, while it can seem as if the metaverse trend has come and gone, in fact, it's likely here to stay. The metaverse currently has around 400 million users worldwide, and it's far from fully mature. As it matures, the legal issues that it presents will likewise evolve and grow in complexity. And really, the issues we'll discuss have application both within and outside the metaverse. So even if your clients aren't engaged in the metaverse right now, most of the principles we're going to talk about have application really in any digital context. I don't want to dig too far into the technology behind the metaverse because that's really a topic for another panel, but I should at least note some basic technology issues that are legally relevant. First, blockchain. Blockchain is in a sense the backbone of the metaverse. It's a digital transaction ledger that enables the secure and transparent transfer of digital assets. Because digital files are inherently falsifiable, without blockchain, a decentralized digital economy in the metaverse would not be possible. And an NFT, or a non-fungible token, is a unique digital representation of value. Specifically, it's an entry on the blockchain that corresponds to an actual asset. Thus, an NFT is essentially a certificate of ownership. It could be for digital art or digital real estate, or even in a case we're going to talk about later, for a pair of real-world Nike sneakers. The metaverse presents new opportunities for companies to promote their goods and services. This could come in many forms. It could be anything from in-game purchases in metaverse gaming worlds to a digital billboard encouraging you to visit a store in the metaverse and make e-commerce purchases that are delivered to your home in the real world. But whatever the context, the widely accepted position in the US is that the same basic rules of traditional advertising, or any online advertising for that matter, apply to advertising in the metaverse as well. This means that metaverse advertising cannot be false or misleading, and any verifiable claims about products or services must be supported by a reasonable evidentiary basis. In addition, although the FTC has not yet taken major enforcement action against unfair or deceptive commercial activities occurring in the metaverse, we should expect this to eventually occur. Generally speaking, the FTC has shown a strong interest in the metaverse. For one, the updated influencer rules that we're going to talk a little bit more about later include provisions regulating the use of virtual influencers in addition to real-world human influencers. And in addition to consumer protection, the FTC is also the primary antitrust regulator in the United States. In 2022, the FTC sued to stop Meta's acquisition of the virtual reality company Within. The FTC feared that this acquisition would allow Meta to dominate the metaverse. Although the FTC eventually lost that battle in court, it nonetheless displays the agency's interest in promoting fair competition as the digital economy enters the metaverse. Now, while the basic rules of the road for advertising in the metaverse may be the same, the audience within the metaverse actually impacts the application of those rules. The vast majority of users of the metaverse are under 18 years old. About half of the users of the metaverse are under 13 years old. Significantly, in the US, whether advertising is false or misleading is considered from the perspective of the reasonable consumer, and this takes into account whether a consumer is an adult or a child. To that end, something that might not be misleading to an adult could very well be misleading to a child. Indeed, the FTC has publicly stated that it pays particularly close attention to advertising that's directed to children because they could be vulnerable to particular types of deception. In addition to the metaverse audience, the type of advertising claims brought over metaverse activity could be a bit different than in the real world as well. For example, because of their importance to the metaverse, advertising claims regarding NFTs and other digital assets, for example, claims about their functionality or their value or their uniqueness, are likely to be subjected to heightened scrutiny. As an example, a class action was filed against the online retailer StockX, a commercial resale platform alleging violations of state unfair competition laws, on grounds that the company misled customers about the availability and authenticity of the products corresponding to NFTs. As the metaverse gains in popularity, more and more brands will employ influencers within the metaverse in order to expand their consumer reach. Of course, in the metaverse, it might not be the influencer communicating with consumers, but a digital representation or avatar of the influencer. Moreover, as artificial intelligence and virtual reality technology develops, it will be commonplace to interact with hyper-realistic virtual influencers that are entirely invented, that is, that aren't a digital representation of any existing human being. Indeed, it may be impossible to tell the difference between the two. Importantly, the FTC has made clear that its influencer marketing guidelines apply to virtual influencers just as they do to real-world influencers. The recently finalized updates to the influencer rules carefully state that an influencer can be an individual, group, or institution, or something that appears to be an individual, group, or institution, ensuring that non-real influencers are captured within the definition. So what are some basic best practices for companies engaging virtual influencers? The first is continue to disclose connections between the brand and the virtual influencer. The virtual influencer needs to disclose that they are a brand sponsor just like a human influencer would have to do. The second, the virtual influencer should not make statements about their personal experience with a product because, of course, a virtual influencer is a computer code. It cannot have an actual experience with a product. Or at the very least, that's a question better left to philosophers. Third, be careful about what the appearance of the virtual influencer implies about a product being endorsed. A virtual influencer, for example, for a hair loss product with thick, luxurious hair could lead a consumer to believe that that's the expected outcome. A virtual influencer for an acne product with perfect skin could have the same effect. Under U.S. law, advertisements need to communicate the outcome that the average consumer can expect. It remains to be seen whether, and if so, how state and federal legislators will react to this trend of virtual influencers, but there has been some early movement on the topic. For example, in California, it's illegal to attempt to incentivize a sale using a non-human bot without disclosing that it's not a human. This is not a metaverse-specific law, but you can see the application. And just as technical progress will allow brands and influencers to profit on the metaverse, it will also become increasingly possible to create lifelike deep fakes of celebrities. This could revolutionize brand sponsorships and endorsements. Imagine a world where advertisements can feature a celebrity without having to fly the celebrity to location and hire a production crew to create the ad, where it can all just be done on a laptop. Similarly, entire lifelike concerts and performances could occur within the metaverse, with the look and feel of a real concert without any of the real-world production costs and challenges. Importantly, though, while this may soon be possible, that does not mean it will be legal. Portraying a celebrity without permission comes at a serious price. In the U.S., publicity rights, a distinct bundle of rights from copyright and trademark, are protected by state law and extend to the commercial use of another party's image, likeness, or other personal identifier, which could include features even such as a unique voice or even a signature dance move. A party's image and publicity is also protectable under trademark law. The Lanham Act prohibits the commercial use of these elements in a manner that results in consumer confusion. So these are some examples of branded entertainment in the metaverse. As you can see, the technological sophistication of these cases is not quite at the hyper-real level we were just discussing. It is very easy to tell, for example, that the image at the top left is not Ariana Grande. Still, publicity rights in the U.S. extend to someone's likeness, not only the actual images of them. As long as it's recognizable, it requires permission from the celebrity. The metaverse and related technologies such as NFTs and blockchain also present novel trademark infringement questions. In 2021, for example, Nike filed a lawsuit against StockX, an online platform that resells sneakers and other goods. StockX minted NFTs that prominently featured images of Nike sneakers. The owner of the NFT could then redeem the NFT for a physical sneaker sold by StockX. Nike claimed that this constituted trademark infringement because StockX was selling a good, the NFT, that was branded with Nike's trademark, which they believed was likely to lead consumers to believe that Nike was behind the NFTs when in fact they were not. But in response, StockX called Nike's lawsuit a baseless attempt to interfere with the popular secondary market for Nike sneakers. And they said that Nike fundamentally misunderstands the idea of an NFT. Under U.S. trademark law's first sale doctrine, StockX is permitted to sell legitimate Nike products, to resell them, that is. And StockX claimed that branding an NFT was merely a fair use needed to identify the products that they were reselling. The Nike and StockX case, assuming it doesn't settle, will help lay the groundwork for how IP rights will be treated in connection with the creation, purchase, and sale of NFTs, including the extent to which the NFT and the physical assets they represent will be considered distinct goods. Now we move on to artificial intelligence. I want to reiterate a point I made earlier. Although AI and the metaverse are distinct concepts, they are conceptually related. Many of the metaverse topics we just discussed inherently raise questions about AI. And the AI issues we're about to discuss are going to shape how the metaverse evolves. So first, what is artificial intelligence? Essentially, it's when computer programs mimic human intelligence, like visual perception or complex decision making. A good rule of thumb is that when we start using verbs traditionally reserved for humans to describe computers, like learning, training, analyzing, creating, we're probably talking about AI. So why the recent boom in AI? Well, part of it is that industry is recognizing the dramatic efficiencies and profits that can be realized by utilizing AI. At the same time, AI is now at the fingertips of the everyday user. Indeed, ChatGPT and DALL-E and similar user-friendly generative AI programs are simpler for the average consumer to utilize than the metaverse, frankly. There we go. Artificial intelligence has the potential to revolutionize advertising because it can impact every stage of an advertising campaign. You need to brainstorm ideas, ask AI to help. Need to develop campaign assets such as social media posts or videos, get AI to do a first draft. Need to analyze mountains of consumer data to develop highly targeted, optimally efficient ad delivery strategy. That's a job for AI too. But as is so often the case, the great promise of AI involves some risks. As we'll discuss, advertisers utilizing AI face potential liability and risks associated with false advertising, unfair competition, and IP infringement and protection. Before we dive into these legal concerns, I thought it would be useful to take a look at an example of an AI-generated ad. Heinz, the ketchup maker, had the idea of asking OpenAI's DALL-E 2 program to draw images of ketchup and see what the results looked like. Well, the results went incredibly well for Heinz. As you can see, each of the images pictured either closely resembles or at least approximates a bottle of Heinz ketchup. This allows Heinz to say, "Don't take our word for it, even AI knows Heinz is synonymous with ketchup." This ad is similar to much of the AI-generated advertising at this stage. That is, the whole point of the ad is to emphasize that AI was used in creating it for the purpose of capitalizing on the buzz and novelty of generative AI. This is likely because generative AI is not quite advanced enough to reliably create, for example, a full-length, lifelike video ad that is coherent and convincing. So advertisers are leaning into the strangeness of AI. But as AI develops, and this is happening rapidly, advertisers will use it to generate more traditional advertising. Many companies that my firm counsels are already beginning to play around with this idea. It's critical to remember, though, that the same false advertising rules that apply to human-generated content apply to AI-generated content. So, if a company uses AI to generate taglines, ad copy, or images, they have to be careful to ensure that they do not create a false or misleading impression about the product or service being sold. The fact that AI created the content does not relieve the advertiser of liability. And in the false advertising context, it's solely the advertiser who would be liable, not the AI platform. The advertiser is the party that employs the false or misleading claim in a commercial manner. Well, one reason this is very important, which Crystal Washington discussed last night in her excellent keynote address, is that AI has a tendency to hallucinate. It cannot yet be trusted. As such, it's critical to carefully vet any advertising content created by AI. For example, just because AI says that your client's company placed first in a national survey on customer satisfaction, that doesn't mean it actually happened. And as we can see on the next slide, AI can sometimes be oddly subservient to its human users. Here you can see the user asks the program to answer the simple math problem 1 plus 3, and it correctly answered 4. Then the user informs the program that the answer to 1 plus 3 is in fact 5. The program promptly agreed and apologized for its mistake. This is obviously an overly simplistic example, but the moral of the story is what we get out of AI will be inherently influenced by what we put into AI and the way we ask the question. An input that consists of a leading question might produce a misleading result. AI can't be trusted to correct our biases at this point. Indeed, it will often exacerbate them. Probably the most frequently discussed legal issue concerning AI is copyright protection. Specifically, who gets protection from AI-generated content, if anyone? The current position of the U.S. Copyright Office is that creative works generated exclusively or primarily by AI, that is, without substantial human involvement, do not receive copyright protection. Indeed, the answer to this question was essentially predetermined by a prior case that did not even involve AI, the now famous monkey selfie case. In that case, a monkey picked up a photographer's camera and took a picture of itself. The photographer then applied for a copyright, but it was rejected by the Copyright Office, which held that the Copyright Act contains an inherent requirement of human authorship. When the Copyright Office was presented with the same question in the context of AI, it came to the same conclusion. Now, that case involved a graphic novel consisting of text written by a human author, but the images were created by AI. The Copyright Office registered the text, but refused to register the images, citing a lack of substantial human involvement. So what's the impact of this? It means that, for the time being at least, an advertising campaign created using AI enters the public domain. No one owns it, meaning anyone can use it. Traditionally, an advertiser owns the copyright in its advertising content and is likely to aggressively pursue another party that copies and reuses it without permission, particularly in a commercial context. With AI-generated content, there is no such recourse. Now, this does not necessarily counsel against the use of AI for advertising campaigns. In fact, it can be quite beneficial. But it is something that needs to be weighed against whatever benefits come from AI. Now, practically speaking, one company may be unlikely to copy and reuse another party's advertising content because, generally speaking, companies prefer to develop their own brand identity. But it will eventually happen. For instance, you can imagine a small upstart brand incorporating or building off of a well-known company's campaign to create something that would otherwise be an infringing derivative work. Finally, the current rule holds that AI can't be owned by anyone unless it involves substantial human involvement. And the Copyright Office has held that simply plugging in a prompt to ChatGPT or DALL-E does not constitute substantial human involvement, even though the human is, in a sense, drawing some content out of the AI program. But in the future, as AI programs become more interactive, this will raise new questions about whether copyright or content produced by AI can be subject to copyright ownership if the human using it is interacting with it in a more detailed way. And here's the catch-22 of generative AI with respect to copyright law. Even if AI-generated content cannot be owned, it can still be infringing. Generative AI programs are trained to create visual and written work product by exposing the program to a massive amount of data, typically scraped from the internet, much of which is protected by copyrights owned by other parties. This process of training the AI based on existing data is how it knows how to respond to a prompt. However, because the program has access to and is trained on existing copyrighted works, this raises the possibility that the program will produce an infringing output. Under U.S. copyright law, to make out a preliminary case for copyright infringement, the plaintiff must show that the AI program both, one, had access to the copyrighted work, and two, created a substantially similar output. And you could likely prove access by showing that the copyrighted work was in the training data set. Substantial similarity is a question of fact for a jury. Thus, if a company were to use AI-generated images or videos in an advertising campaign, and the content was substantially similar to existing content used to train AI, this would potentially expose the advertiser to copyright infringement liability. And this is the case even though the advertiser didn't create the program that made the content and doesn't even own the output. It's enough that the advertiser publicly displayed the content. Now, there's some disagreement around how likely it is that generative AI programs will substantially copy existing works in their outputs. Generative AI technology is still in its early stages of widespread consumer use. And over the coming months and years, it will likely become clear which platforms present more and less risk. It also remains to be seen whether AI companies will find ways to properly license the massive amounts of data used to train their programs, which would effectively remove the copyright infringement problem altogether. Some companies are already getting there. Adobe Firefly, for example, a generative AI art program, is advertised as ethical AI because it's trained exclusively on Adobe's library of licensed images. For the time being, though, most generative AI programs do present at least some infringement risk to advertisers. So how can companies utilize AI for advertising while mitigating the risk? Well, there's no way to eliminate the risk, but there are ways to lower it. The first is obvious. Don't ask AI to infringe. If an in-house marketing team asks AI to create a series of images based on another company's content or based on an existing work of art, the likelihood that the AI is going to produce an infringing content substantially increases. This seems obvious, but it's important for companies to educate their employees on these issues. Next, I always advise clients to engage in a thorough diligence process before publishing any AI-generated content. This includes Google searching text produced by AI to see if it returns identical hits. There are also programs that will do this for you. Companies can also reverse image search any visual content. In the future, we can probably expect AI actually to do this for us and to do the clearance that we're now doing manually. But at this time, most companies are doing it the old-fashioned way, plugging it into Google and searching it to see if any problematic hits come back. In the U.S., there are a number of pending lawsuits alleging copyright infringement in connection with artificial intelligence. But so far, these lawsuits have been filed against the AI platforms, not companies or individuals that are using the content produced by AI platforms. These examples of defendants are OpenAI and Meta, right, rather than individual consumers and businesses. And what these lawsuits allege is that the program creators infringed their copyrights, the plaintiff's copyrights, in the process of training the AI programs. That is, the background process of training it on data sets before the AI program was commercially available to users. So AI companies generally argue that the training process constitutes fair use and is thus not infringing. These lawsuits are in the early stages, though, so we don't know how they're going to turn out. The results, however, are going to play a major role in shaping the future of generative AI in the United States, and in turn, how accessible it remains to the average consumer. Another important issue to consider for companies utilizing AI is the possibility of FTC enforcement based on unfair competition violations. The FTC has made clear that it intends to regulate AI-driven advertising practices under its authority to attack unfair or deceptive acts and practices. Indeed, this aligns with the FTC's interests in dark patterns that we discussed earlier. Imagine, for example, using an AI-driven deepfake to influence a consumer's purchasing decision without disclosing the artificial nature of the interaction. This is something that the FTC would certainly take issue with. They would definitely investigate it, and they might take enforcement action against it. The FTC is also concerned with the possibility that AI could be used to exacerbate discrimination in the United States. Here's an example provided by the FTC. Let's say your algorithm will allow a company to target consumers most interested in buying their product. Seems like a straightforward benefit, right? But let's say the model pinpoints those consumers by considering race, color, religion, and sex, and the result is digital redlining. If your model does more harm than good, that is, if it causes or is likely to cause substantial injury to consumers that is not reasonably avoidable by consumers and not outweighed by countervailing benefits to consumers or to competition, the FTC can challenge the use of that model as unfair. Finally, let's use an example to make these issues come to life a little bit. Virtual fitting rooms and try-ons are a fascinating use of AI that has the potential to be very beneficial to consumers. Indeed, the idea of pairing online shopping with the ability to try on the item first is incredibly appealing. Just imagine the savings on return shipping. But there's also potential for consumer abuse. What if a company systematically manipulated the AI to make sure that the products fit your body perfectly in order to persuade you to make a purchase? But in reality, it doesn't fit so well when you get it in the mail and actually try it on. Some consumers will return it, but others won't, and the company will make a profit. Make a profit on that manipulation, that is. What if the program alters your proportions to make you feel more attractive, improve your mood, and make a sale more likely? Or what if an AI-driven acne product showed you with perfect glowing skin and a skin tone that you could never actually achieve? These are the kinds of practices that regulators will inevitably target. As lawyers, though, we're in the privileged role of helping clients engage with new technology to generate commerce and satisfy consumers while staying within the guardrails established by the law. And with that, I will return the floor to Fernanda.
Much. I think, yeah, you can hear me. Thank you so much. This is incredibly insightful and challenging for sure. I said earlier, and I wrote down here to correct myself, that the advertising industry is perhaps going through a revolution. And I wrote down that actually content industry, any content creation is going through a revolution. Any sort of, from a simple email, writing a simple email to preparing an advertising campaign, all of that content is being revolutionized by all these technologies. You mentioned, just to go back on a few slides of your presentation, about work created solely by AI not being protectable under U.S. copyright. And I can say the same rule applies for the Brazilian copyright law. But as unprotected work, as you also mentioned, the product will come to the public domain. So can you mention to us how do you see the appetite of especially agencies and brands in terms of this, at least for now, lack of certainty as to how their advertising will be possibly end up in the hands of a competitor, and they will have no claim in terms of copyright to protect that content? Are they going for it with a huge appetite? Are they testing the water and maybe going for more, quote, commodity advertising, so the specific of the week message, or are they thinking about something bigger? How's content being looked at from that perspective of value?
Yeah, thank you. And it's a great question. Right now, in my experience in the U.S., advertisers are going for it. They're being persuaded just by the potential for significant amounts of attention that are drawn by AI advertising. As I mentioned, at this point, advertising using AI is very obviously created by AI because the technology isn't quite sophisticated enough to produce like a traditional ad that you wouldn't know was created by AI. And that has the potential to generate a ton of buzz. So right now, companies, our firm counsels companies all the time and explains to them, like, if you use this and you publish it, in theory, someone else could use it and reuse it, and they generally are willing to take that risk right now. Now, we'll see if that changes over time. One thing that I think is worth noting is that if we consider the Heinz ketchup ad, one way that you could prevent another company from using your advertising is ensuring that your trademark is in the ad, right? So if a bunch of bottles of ketchup that closely resemble a protectable Heinz ketchup trade dress are in the ad, reusing it is not possible because the copyright issue is irrelevant, right? You have other avenues to pursue the infringement, and that may ultimately be be what happens, even if someone is able to reuse the copyright in the image, or I should say, the copyright doesn't exist, so someone is theoretically able to reuse the content without violating copyright law. There may be other avenues like unfair competition or trademark law that we can use to get there to at least have a reasonable basis for sending like a cease and desist letter.
But that makes me think, how can you be sure that you're the one that actually created that to be the copy of somebody? Maybe you have copied yourself, somebody else's not non-copyrightable work.
Right.
So it's a very difficult equation when it comes to the practical, okay, here's my ad, here's the competitor's ad, what can you do for me? A lawyer, please help me out. And we're going to have to paddle back a long way back to be sure that there is even an actionable claim there, right?
Yes.
And do you have any insights as to the agencies? I mean, that's definitely that the AI means an opportunity, but certainly a challenge in terms of the current and old model of advertising campaigns. And you talked about production costs and the effect. Do you have an insight to how they're playing? Are they playing harder balls in the contract with their clients? Something in that range?
Yeah, another good question. So we're going to see more and more how agencies evolve in this way. Agencies obviously are starting to use AI to create ad campaigns because brands want them to. And one thing that brands are going to start pushing for more and more are to place representations and warranties and indemnifications onto the agency to say that even if I can't own this, you're representing that it's non-infringing. And agencies are going to be very resistant to that because it's, as I kind of talked about, it's difficult at this stage to ensure that what you're using is non-infringing. This may become easier as AI platforms evolve, and we can say with more certainty that the entire data set associated with a particular AI platform is licensed. And so there's no copyright infringement risk. But right now we're seeing agencies resistant to the idea of indemnifying a brand for the advertising campaign, which is something that they would historically be more willing to do because of the ability to vet the copyright ownership.
Perfect. Yeah, that was something I wanted to hear from you. Wonderful. You spoke about IP infringement, and I wanted to ask you about liability. So we're talking a little bit on the contract front here, but as the terms and conditions of the platforms, the AI platforms, also evolve, can you tell us how it would normally work if consumers are misled by an advertising campaign and a competitor? I think you spoke a little bit about that already, but if you want to go deeper.
Yeah, so, sorry. With an advertising campaign, it's the party that actually publishes the content that would be facing liability, right? It's a little bit different from copyright in that sense, where if, say, for example, a company created an advertising campaign using an AI program and it infringed another party's content, in theory, the plaintiff could go after the company that used the content and could allege contributory infringement to the based against the AI platform. In the false advertising context, it's different because there's no in the copyright context, the argument is that the AI program is making a copy of it. That's a necessary step to it being used. In the false advertising context, the violation is triggered by just the publication of the false or misleading statement. So in that case, it would only be the advertiser that would be likely to face liability. Yeah.
Wonderful. I have one more question here prepared for Thorne, but I don't know if the audience has. So since we have about five minutes, I'd like to open for questions from the audience. Please.
You mentioned that the FTC grants no rights if the text has been created by an AI.
Yes.
How does it understand that the text has been created by an AI if I don't declare it?
Yes, it's a really good question, and it at this point is relying somewhat heavily on the honesty of the party applying for the copyright application.
Yes. So no way for someone else to say no, you have no rights because an AI has created your text.
Right. Well, I mean, someone could challenge it, right? And you could challenge a copyright registration that granted in court if you had reason to believe that, if for example, this could could be a potential counterclaim in court. If someone alleged that your activity infringed their copyright, and then you said, well, they shouldn't actually have a registration because their content was created using AI, and so you need to the Copyright Office should actually cancel their copyright registration. So it could come up and become a basically a fact-based discovery issue. The onus of, well, in that case, it would be a burden sharing issue for litigation. So the plaintiff would need to allege a reasonable basis for the idea that the content was actually created by AI, and then the defendant would have to show that provide some sort of proof that I actually created this. So it's actually, we counsel companies to maintain some record of your copyright assets to show that it's not made by AI.
That's a great question, because I think this advice is at this point gold. If you're going to play with AI, and if you should definitely keep record of how you're getting to that point, because you can prompt the AI in several ways. You can start from ketchup, and then you say ketchup in the moon, then you say ketchup in the moon at night, and you go on and on and on. If you can show those prompts, at least you're going to have a spine of your creativity to show, how you created. It wasn't just give me a great commercial for ketchup kind of thing.
In the end, I think that the way you prompt is a particular way of using a tool in the end.
Yes.
So it should produce something which belongs to you.
Right.
It's a good question, and it's uncertain under U.S. law right now, because what we know is that the Copyright Office has held that if you simply say, "Give me a picture of the moon," and something comes out, that's not enough in the Copyright Office perspective. That is not a creative step, right? But if you said, give me a picture of the moon, and you separately said, give me a picture of stars, and give me a picture of the night sky, and you merged them into your own work together, then you might have a derivative work created that you own some rights in that derivative work at least.
Great. Please.
Congrats for the presentation. Just a very short question. I'd like to hear from you about the importance of building policies, internal policies within the agencies, the companies, and even within our firms on the use of AI tools. We know that people use, but is it a good idea to try to at least regulate or to give a sign if should we foster this use or should we prevent it? Maybe it also deals with the culture of the company. Yeah. I'd like to listen from you.
Yeah, so I think from a commercial perspective, using AI is going to become imperative. In Crystal Washington's keynote, she said something that I tend to agree with. Regardless of your feelings on whatever risks AI poses to society, it's likely the case that humans that use AI are going to replace humans who don't use AI. So from that perspective, building in guidelines into a corporate environment is essential, because all of a sudden we're going to have employees that are going to ChatGPT or going to DALL-E or something like that to create assets, and the legal team might not even know that they used AI when it gets to their desk for a review. Right, so there needs to be a standardized way of disclosing now exactly how the sort of brand assets and advertising collateral is arrived at, because otherwise we don't actually know what we're reviewing as a legal team, and we don't know what legal regime applies to it, right? And the same goes for the discrimination issue that I was talking about. That's a real concern in the U.S. of the STC, right? The ability of a company to use AI-driven algorithms to target advertising in a way that is discriminatory and that potentially exacerbates divides that already exist in the country. And that's something that I think training and sensitivity training from an internal corporate perspective is important, to make sure that when we're using advertising to increase profits and to target an ad directly to someone who is the exact right person that needs to see it, that has the exact highest probability of making a purchase, that's a good thing. That's a good commercial practice. It gives the consumer what they want, and it feeds money into the economy, but it's a razor thin line between discriminating, right, and making someone who doesn't really need to make a purchase that you know they're going to make, even though you know they shouldn't make it, right? So there's a rights and responsibilities question that comes with AI.
That's great. Well, we'll be exactly on time, so I just want to say, Thorne, thank you so much. This was incredibly insightful. I'm sure everybody has a lot of questions to think back home about using of AI. I think for advertising, this is an opportunity. We're going to see a lot of questions coming our way. And my view is that the more you're aware of the implications, the sooner as a brand you can prepare for it. It's going to come, it's going to happen. And so it's just a matter of how ready you're going to be, or if you're going to be the first leading case
right.
of what
Yep.
went wrong. Thank you so much.
Well,
It was a pleasure.
thank you for having me. It's an honor.
Thank you very much.
Eu botei aqui, falei, ninguém respondeu. Foi, né?
Ainda ficou uma pergunta pendente ali.
Obrigada, tá?